Now, what are we going to talk about today? So we're going to talk about the relationship between the General Data Protection Regulation and the Fifth Amendment Directive, specifically how the GDPR affects the Fifth Amendment Directive and what can you do about this. So what are the elements that you have to consider in this regard? Now, as I'm pretty sure the previous speaker yesterday already said, the existence of previous crises and scandals in the European Union pushed European institutions to the update of the previous legislation in terms of anti-money laundering. Now, in regard to the topic I want to talk here today, I will focus in this update with the Fifth Amendment about the strengthening of the FIU, the Financial Intelligence Unit, and specifically the strengthening of the register for beneficial owners that has been centralized throughout Europe. So as you know, specific centralized register per each member state. Now, the system here is to, again, it's once more to strengthen the European area, the European market, and to protect its citizens with the centralized, systems. And this is all part of the biggest plan, let's say, the European Union of the also the digitalization process of the European economic area. So I'm pretty sure that all of you know the Digital Single Market Project. So essentially the digitalization of the European economic area. And the necessity, in order to allow this digitalization and to be sure that this new legislation that will perfectly be integrated in the system, that the oil of the digital economy, of the digital market, so data, what has been defined as the oil of the 21st century, can freely flow inside the European economic area for private purposes and for public also purposes, as you can see here. This is recital 5 of the GDPR, that identified the necessity in the digital economy to let that data, also personal data, can freely flow in the European economic area. Now, this means that in terms of this Fifth Amendment, the Fifth Amendment Directive, this strengthening of the Financial Intelligence Unit and the creation of the register, it's actually it requires necessary this transfer of data. It's very important, the access to the beneficial owners' data, and then this can be transferred for public purposes, for example, from the Financial Intelligence Unit for investigation, money laundering, terrorism financing, but also under certain circumstances for other purposes that we're going to see together. However, all of this has to consider this new legislation, so the GDPR, the cornerstone of the new data protection framework. Now, this is not just the legislation. This is the cornerstone. The framework is much bigger, but it's extremely important for any single company, any single controller, processor, anyone who is dealing with personal data, not with data, with personal data. So data related with people. It is essential that any single legislation that will deal also with personal data will consider the GDPR. And this is what we're going to do. We're going to see how the GDPR impact to this legislation. Now, specifically because time is brief, the element that we're going to see together that you have to consider are mainly three. So number one is duties. So which kind of obligation you have to consider when you're dealing with the GDPR in the Fifth Amendment, how the 6+1 principles, this is a personal definition, it's not an academic definition, but how the data protection principle impact in the amendment and in your specific obligations. The number two, about the rights. So how does the GDPR, how the rights that data subjects have according to the GDPR impact your obligation with the Fifth Amendment Directive? And last one, security. Because when we talk about digital economy, we also talk about digital infrastructure and the necessity to protect this infrastructure in technical and especially what we're going to talk here in organizational way. So obligations, rights, security. These are the three elements that we're going to see together. Everything's clear? Very good. Okay, so number one is the principles. So when you talk about the principles of the GDPR, now you have to forgive me, but I have to presume that you have general knowledge of the GDPR, so that some words that I will say like controller process, so you already know about this. So when we talk about the 6+1 principles, again, this is not an academic definition, but I like to consider this as one of the two legs of the general data protection regulation. So one is the principles, and the other one is the rights. They both, on different sides, they deal and they want to protect personal data. One is from your side, so data controller, data processor, and the other one on the side of the data subjects. Now, back to the principles. The principles are 7, and most of them, let's say they come from previous legislation, and they want to ensure that you will comply with, and you will comply with certain specific elements, like that you are transparent, that you identify why you have to process personal data, that you do not collect too many data, so that you essentially, let's say, erase from your mind the just-in-case approach. I collect data just in case. That you keep the data accurate, storage retention, so that you don't keep them for too long, that you protect the data, and my favorite, the new entry in the GDPR, that you know who is accountable for it. So if there is any violation of the GDPR, that you know what your responsibilities are. Now, all of these principles impacts specifically in the context of the register, so the creation of this centralized register for beneficial owners in your obligation. And starting with the principle of transparency. So principle number 1, the principle of transparency says a lot of things that personal data have to be processed in a fair, clear, transparent way, and so on and so forth. But for you, specifically for you, what you have to consider here is the lawful aspect of the principle of transparency. And this means that as the first necessary step, when you have personal data of your clients, your customers, your employees, even eventually, you have to find the legal justification for it, for collecting this data, storing this data, transferring this data. You need to be able to find a legal justification, and the GDPR provides a few examples. It says that one lawful basis can be consent, 2 obligation, contractual or legal obligation, and my favorite, what I like to call it the dodgy area, interest. Vital, public, or legitimate interest can justify your processing activity. Now, what you have to consider here is that with this basis, with the lawful basis, it doesn't work like, I don't know, one is always the best one. For example, I don't know, let's ask consent to everybody for every single thing. No, it doesn't work in this way. Or we are processing data because we have a legitimate interest for it. It doesn't work in this way. You need to see, according to the different scenarios, I don't know, employees, contractual obligation, marketing purposes can be consent or legitimate interest, implementation and compliance with the 5th Anti-Money-Laundering Directive, legal obligation. So the creation of the registers, the processing of financial data that are in the registers, these are also personal data because they're related to people, where your legal justification, your lawful basis for this, it's based on the 5th Anti-Money-Laundering Directive. It is not consent, so do not ask for consent, for example, to clients, so do not rely on some kind of supposed legitimate interest. There isn't. It's this that is your lawful basis. Now, if one is related, if the first principle is related to the lawful basis, you also need to explain why you are processing this kind of data. You cannot simply say, I have a legal obligation, then I have to process personal data. It doesn't work in this way. So you need to explain why you are doing this. Are you processing personal data, for example, of your clients because you have to provide financial services? Or personal data of your employees because, I don't know, you have to pay their salary, pension funds, and so forth? Well, specifically in this case, specifically for the principle of purpose limitation in the 5th Amendment Directive, what is your purpose? Why are you creating this register? Well, actually, you know it. We already said, so fighting terrorism financing, money laundering activities. So this is your why. Now, consider that this principle works like in order, okay? So it's not like that you pick one and you do whatever you want, so you have to go in a certain order. And if the first two, the principle of transparency and the principle of purpose limitation, identify the why, the other two, minimization, accuracy, they're more about the quantity and the quality of data. This is a big problem, actually, because in the age of data, in the age of big data, you know, when you have something and this is not particularly expensive, or actually it's free, what you do, you accumulate, and no one cares about it. And this is actually what the GDPR would like to avoid or to reduce, so that the data that you have, for example, that the data that you collect to include in these registers, again, according to the First Amendment, comply with the principle of data minimization that says that you do not have to collect more data that you need for a specific purpose. Just to give you an idea, classical one, if I have to send, I don't know, a package to one of you, I will need your name, surname, address, email address. I don't need, I don't know, your sexual orientation, your political opinion, your trade union membership, and so forth. And this is the same identical thing that you have to consider this here. And actually, the Fifth Amendment, if you go on Recital 21, specifically indicates here, it recalls the privacy and data protection legislation. It says that when you are creating this register, so the data, the financial data that you include there, considering privacy and data protection of personal data, the minimum data necessary for the carrying out of this kind of obligation have to be considered. So the minimum amount, and what kind of information do you have to include there? Well, again, the Fifth Amendment directive indicates, let's say, the minimum kind of information that you have to include there, from account holder to or representative to date account, IBAN, beneficial owner. However, I want to be very careful here, because if this is again, in compliance with the principle of data minimization, if these are the elements that you have to include, it's also true that we are talking about a directive here. We are not talking about a regulation. And actually, trust me, even with the regulation, there is a lot of fragmentation, but this is another topic. Because we are talking here about a directive, you need to check your national legislation, because, as you can see here, again, the amendment directive indicates that member states, it should be possible for member states to determine which data is useful and proportionate together. Translated means the data that we saw before are the minimum that every single state has to include in the register, but this doesn't mean that states cannot eventually include additional information, always, again, according to certain boundaries that also consider privacy and data protection. So depending on which kind of national law you have to comply with, you need to see which kind of information you have to include there. And if you have other data that you cannot include in the registers, that you cannot use for any other purpose, for any other different purpose, for example, account balance, I pick one. Well, when you have data and you do not have legal justification, you do not have purpose for it, well, there is one thing that you have to do. Get rid of them. Again, it is not that, oh my God, I have the data, I do not know what to do. You need to see the data and say, okay, can I justify the retention, the processing, the use? Yes, okay, you can use it. No, I cannot justify this in any way. I cannot be transparent. When? Get rid of them. Now, in terms of quality of data, not just the quantity, but also again the accuracy of the data. It's extremely important, because a lot of data, a lot of issues in terms of accuracy of the data, whether personal data are up to date. So in this case, again, with the Fifth Amendment, consider this. Are you really sure that the information that are in the register correspond with the beneficial owners? Well, which kind of system do you have in place to check the accuracy of this? Do you use automated means? So, I don't know, automated processes, or I think it's not your case, but just to mention, paper files, for example, not automated means. How do you check? Which kind of systems do you have in place for checking the accuracy of this? This is something that you have to consider, because the accuracy of the data, keep the data accurate and up to date, it's one of your obligations. Now, we are almost at the end. We will skip security. We're going to do this later. A very hot topic since the approval of the GDPR was the storage retention, because one of the problems was the great accumulation of data, of personal data, and the other one was the retention period for an indefinite period of time. When I started to talk to people and talking about this period of retention period, they say retention period. What's retention period? Because they keep this for an indefinite period of time, and you cannot do this. So you cannot keep personal data for as long as it's necessary, so no longer than it's necessary. Necessary for what? Well, when you define your retention period, and again, for the data that are in the register, so in the centralized register, consider your purpose. So as long as you have a purpose, for example, I don't know, I have to keep IBAN information, I have to keep account holder information because I have to provide financial services to my client, where as long as you have this kind of purpose, then you can keep the data. But what happens if, I don't know, there is like the end of the contract? What do you do? What do you do with this kind of data? Well, in this case, the GDPR says that, well, you can rely eventually on a legal obligation. I do not have any relationship, for example, me by former employee or with my client because we end the contract. Can I still keep part of this data longer than the purpose? Well, of course you can. And this is also indicated in the Fifth Amendment. In fact, it says, if you go on recital 21, it says that it's possible to extend the retention period of the information contained in the registers 5 years additionally to the end of the purpose. Now, I want to be very, very, very careful about this, and it's very important for you to check your national legislation, because this is one aspect that is indicated in the, one aspect of the retention period that is indicated in the amendment, but there are many others. And again, I'm afraid to say that because we are talking here about a directive, not a regulation, you need to see how states, member states will deal with the national, at the national level with the retention period. So you have to check your national legislation also in this case. Now, as I said, we skip security. We see this later. And we go directly to the new entry of the GDPR, the one that essentially got the attention of everybody. I would like to say everybody in the world that have been affected by the GDPR, and it's the principle of accountability. Now, what do we mean when we talk about the accountability? Now, I hope you will forgive me. I will try to summarize this very briefly. Two elements that we consider is, on one side, the legal responsibility. So who is legally responsible for complying with the GDPR, and who is legally responsible if something goes wrong? Very important thing. And on the other side, that those who are accountable for complying with the GDPR, they also have to have a proactive approach. So you don't simply have to comply, you have to demonstrate that you are complying. If there is a data breach and someone's come to you, and for someone's I mean data protection authorities and so forth, and they ask you why there's been a data breach, you do not simply have to say, yes, I implemented my security measures, but you need to demonstrate that those security measures, for example, were appropriate for you. Now, usually when we talk about accountability, we talk about controller, processors. Now, I know that you perfectly know this, but in this specific case, what we can say is that, for example, banks, financial institutions, they work as data controller, and a processor, so the one, for example, that it's processing data on behalf of the data controller. Think about your cloud provider, just to give you an idea. Well, in this case, in this relationship, you usually have an accountability on the side of the controller mainly, okay? And then it is extremely important that in this relationship, because the controller is mainly accountable for compliance, that you clearly defined roles and responsibility here. So data protection agreement, a DPA, it is important. What kind of data the data processor can store? For how long this can be done? Are the security measures appropriate? Now, it is funny because usually when people think about data controller and data processor, they think, okay, so data controller, mainly accountable for compliance with the GDPR. The other one is only doing what the controller told him, so this has to be the data controller, big one. And all the tiny data processors that are storing the data on behalf of the data controller, that are transferring data on behalf of the data controller, that are, I don't know, payroll, iCloud providers, and so on and so forth. But actually, in the present situation, this is most common. You have a big data processor. Again, think about cloud providers, from Google to Microsoft, from Apple to Amazon. And then you have small or smaller data controller. Now, in your case specifically, if you consider this register, and again, I do not know how it is in your specific cases, but if you consider, for example, the centralized register kept on a cloud provider, one of the problems is that if you have a group of controllers that are processing data for the same purpose, the same means, well, in this case, you have joint controllers. So all of them are jointly accountable for compliance with the GDPR. This means that if something goes wrong with the data processors, they are all, let's say, they are all accountable for it. And this means that any data subject can come to one of these data controllers, can come to one of you, and all the other controllers will be jointly accountable for compliance. So this is something that you have to determine. And in this case, it is also very important that if you have a joint controller situations, that also you do not simply have a contract with your data processors. This is fundamental. This is essential. But it also you know how to manage your relationship with all the other controllers if something goes wrong. If there is a data breach, what do we do? Now, I hope this gave you an idea, let's say, on how the principles, so the first leg of the GDPR impacts on the of the Fifth Amendment Directive. And this is the first pillar, so the 6+1 principles. Now, if from one side you have the principles, on the other side, dealing with the same identical problem, so protection of personal data. On the side of the data controller, you have principles, you have obligations, and on the side of the data subject, you have rights. In the same way, these two want to deal with the same identical things, and then why this right exists? Well, essentially it exists because if you, as a data controller, you are not taking a proactive, let's say, you do not have a proactive approach, you are not comply properly, where then a data subject can go to a data protection authorities, for example, saying that you do not give them, you do not give to that person access to the data. That maybe you are not erasing the data and you cannot prove why you want to keep the data, and so on and so forth. Well, then the data protection authority can go to the data controller, and the data controller, depending, of course, on the case, can come to you and fix the issue. Then, essentially, we are talking about the same identical thing with the rights. We are talking about the same identical issues, just on a different perspective. Now, these rights are quite a lot. I told you I will not push too much, so we're gonna briefly see them. And they are not all a new entry in the GDPR. Some of them already exist in the past. Some of them, like for example, the right of access, they exist in the 70s, so it's not really a new, it's not a new right. Like the right to be informed and right of rectification, these already exist. Erasure is a new entry. There is a lot of confusion between erasure and a right to be forgotten. Everybody thinks it's the same thing. I've also found a lot of privacy notice when people say, you have the right to be forgotten. That's not absolutely true. Right to be forgotten works when your information goes in the public domain. So unless anyone here works for Google, Bing, Microsoft. Okay, so for you, the main issue is the right to erasure. So the right of a person to see his or her data erased under certain circumstances. Restriction and portability, objection. So most of them, they are new entry. My favorite, the right not to be subject to automated decision-making processes. I have no idea why this right is so long, the name of this right is so long. Anyway, so this is a right that essentially was copy-pasted by the previous legislation, but now, with all of this new artificial intelligence, let's say, development, is going to have a huge impact. Now, I told you that I won't push too hard, so we're going to see only 50% of them, so only 4 of them, that will directly and immediately impact on you with your compliance with the Fifth Amendment. Now, as I said, right, principles. So one, essentially, is dealing with the same topic on the other side. And if you think about the right to be informed, so right to be informed is the right of every data subject. This is the definition that the GDPR gives to people. So data subject has the right to get his information in a clear, concise, transparent, intelligible way. Well, if you look for the principle, actually it's the first principle of the GDPR, the principle of transparency, that is dealing with this issue. So your obligation is to provide information about how you are processing data of your client, of your employees, in a clear, concise, transparent way. And on the other side, the data subject has the right to tell you, hey, your privacy notice, I do not understand anything. Privacy notice, you can call it, I saw so many names, privacy notice, privacy policy, privacy declaration, privacy promise, privacy statement, call it as you want. But if you do not specifically indicate relevant information in the privacy notice in a clear way, design, it's a very big issue, so in a way that it's understandable for people, that people can understand you, well, then you're violating the right to be informed. So, and actually, the right to be informed here, it affects the Fifth Amendment because for the information, for the personal data that you include in the registers, well, there is actually, as you can see here, there is in the Fifth Amendment, if you go on recital 38, there is a reference on the rights of the data subject that you have to communicate in the privacy notice, but not simply. If you see essentially the last sentence here, you also have to communicate the procedure for exercising those rights. So one thing is to say, hey, you have the right to erase your data. Thank you very much. How do I do this? Hey, you have the right to rectification. Wonderful. How can I do this effectively? So this affects you in 2 ways, clear communication and also an appropriate exercise of these rights from the data subjects. And this is also work for the centralized registers. Now, the second right, it's one that got a lot of companies got huge headaches and everybody got crazy because they thought that like from one day to another one, the world would explode, and it's the right of access. So it's a right that already exists and that it's steadily increasing, let's say, in its exercise, and is essentially a form of control that data subjects have on how you are processing personal data, on your compliance. As I said at the beginning, rights and principles, they essentially deal with the same topic on two different perspectives. But with the right of access, as you can see here, essentially the data subjects, your client, your customers, you as employees, for example, well, they are exercising a form of control on this principle here. 1, principle 2, principle 3, and principle 4. So I want to see, with the right of access, when a data subject comes to you, your bank, your financial institution, and it's asking you, hey, how are you processing my personal data? Why you're doing this? What is the lawful basis? Are you keeping this data in your register for what kind of purposes? What kind of data do you have? Hey, my data are not accurate. So this is a form of control the data subject can exercise on you. And again, you have to indicate in the privacy notice and how this kind of right can be exercised. Now, talking about the right of access, what I want to focus with you, and it's extremely important, it is extremely important here in relation to the Fifth Amendment, is the fact that the GDPR allows the exercise of the right of access from the owner of personal data. So I can go, I don't know, to a company, I can go to a provider and ask them the access of my data, but the GDPR also allows third parties to access data on behalf of the process owner, of the data owner, under certain circumstances. Now here it's important because when you talk about the Fifth Amendment in regard to the registers, so the possibility to access to the registers, now the Fifth Amendment directive indicates this possibility to access this kind of personal data for the FIUs, so for the Financial Intelligence Unit, for anti-money laundering, terrorism financing, anti-terrorism financing purposes, but also, and this is the new one of the new entries, for legitimate interest. So someone that has a legitimate interest can eventually get access to this register. Clear, right? Well, actually it's not, because the problem is, what is a legitimate interest? How do we define here legitimate interest? Now, again, I will use my magic sentence. You have to check your national legislation. Because, again, the directive, again, says that the legitimate interest should be governed by the law of the member states. And again, if you continue, you go on recital 42. Specifically, recital 42 identifies the legitimate interest. So in order to define the legitimate interest, member states have to take into account the previous legislation. So they say, okay, if someone has a legitimate interest, they can access to the registers. Now, the fact is that how is defined this legitimate interest, it is left by the member states. So check your national legislations. This is very important because it depends from state to state, from, I don't know, UK pre-Brexit to Germany, from Spain to Portugal, from France to the Netherlands. What is a legitimate interest? How is legitimate interest identified by a member state? Okay. The last two. So the last two rights. Rectification. Here we are again on the quality of data. And if you remember what I told you about the quality of data, the link, let's say, of this right, so the right of every single person to have his or her data rectified when they are inaccurate or incomplete, well, as you can imagine, this is specular to the principle of accuracy. So your obligation as a data controller to keep the data accurate and up to date. Right of the data subject, so right of the owner of this data to rectify this data when they are not inaccurate, when they are inaccurate or not up to date. And again, also here for the registers, again, recital 38 identify this necessity that this kind of data that have to be used for serious purposes. We're talking about terrorism financing, anti-money laundering activities, and so forth. So you have to be sure that these data are accurate and up to date. And how to do this? Well, it's up to you. It depends from your processes, from the level of technology, how you ensure that the person can exercise this right and that you indicate this in the privacy notice. By telephone, I send an email, other digital tools. So this is up to you. Now, last one. Now, the last right, it's probably one of my favorites. Again, we are talking here about the right to erasure. We are not talking about the right to be forgotten, okay? As we said, these are linked, but are not the same identical things. So as you can imagine from the name, the right to erasure, it is essentially the right of the data subject to get his or her data, the data subject has the right to have the data erased under certain circumstances. And there is a list in the GDPR that it's quite broad. But if you want essentially to summarize this, so when the personal data have to be erased, well, essentially when you do not have lawful basis, when you do not have purpose, or when you are obliged, you have to comply with the legal obligations, you have to erase this personal data. And if you think about this, you see how this is peculiar to the storage retention. So principle of storage retention, you have to keep the data as long as the purpose or as long as the legal obligation. If you do not have the purpose or you do not have the legal obligation, what you have to do? You have to erase the data. Now again, if someone comes to you and exercise an erasure request, you don't have to freak out and say, oh my God, I have to erase the data. You have to check, okay, let's check. What is this kind of data? Well, these are data from from one of my clients. Well, do we have to erase this data? Well, no, we still have a contract. We are providing them, we're providing him or her financial services. Other case, so we have a purpose. Other scenarios. This is my former clients want me to erase all of his or her data. What do I do? Well, I have the data in the register, and I still have 5 years extra, additionally from the end of the purpose, to keep this data, so I cannot erase this kind of data yet. For all the others, you have to erase them, and again, check your national legislations. Now, as I said, so we only got an overview of a very, very brief overview of this second leg of the GDPR, but again, consider that these two are essentially part of the core of the legislations. Roles and responsibilities and rights. So last part, and I can assure you it's the shortest one, it's about security. Now, when we talk about security, we talk about several things. So what I want to focus here is the organizational aspect. I will give you a very, very, like a glimpse of a legislation that it's called NIS, the NIS directive, that actually work in conjunction with the GDPR, and especially for security, it's quite important for you to have an idea of it. And then I will give you a brief mention of the DPIA. That's it. So, breach notification. Now, as you know, security, and especially cybersecurity, is becoming an encompassing issue now and especially in the future. So cybersecurity attacks and, broadly speaking, security issues of any kind, technical and organizational, are growing. So more and more we go to a digitalized system, and in some cases a centralized system like this one, and more you have risk that one breach can have catastrophic effect on the entire system. When everything is centralized, you have to protect this in a proper way, because otherwise this is going to have a cascade effect. Now, the GDPR, amongst the other things, consider the organizational aspect of security, specifically in terms of a data breach and a communication mechanism that you have to have in place if there is a data breach, if there is a security issue. And identifying stakeholders, let's say the relevant stakeholders here, we can identify 4 of them. Processors. Let's say the provider, your cloud provider, for example, that is storing the register. The data controller, it's you. Those who are controlling data protection authorities, and the owner of this data, the data subject. Now, there is a pretty clear, let's say, channel of communication in the General Data Protection Regulation that identifies a mandatory obligation for the data processor when there is a security breach. So any security breach, no matter what, and you have to indicate this in your data protection, in your data processing agreement, any security breach has to be reported from the data processor to the data controller, no matter what. It can be sending an email to the wrong recipient. It can be a hack attack. It can be flooding, fire, security measures. No matter what, you always have to communicate it, because it's the data controller, so it's you, if there is, for example, a problem with the register, that you have to consider whether or not there is a high risk. And a high risk you have to determine by your own, considering, I don't know, how many people have been affected? 1, 1,000, 1 million? The nature of the breach. Are we talking about sending an email to the wrong recipient, or maybe a hack attack? You have to consider your security measures. Were the data anonymized, pseudonymized, encrypted, and so forth. And then, if you think that there is a high risk, you have to communicate it to the monitoring authority, to the data protection authority. And the GDPR says, without undue delay, maximum 72 hours. Now, please, it's not maximum 72 hours, it's without undue delay. I do not know why everybody says 72 hours. Okay, I have 72 hours. It doesn't work in this way. It's without undue delay, so as soon as you know this, maximum 72 hours. So if you see that there is a high risk after 24 hours, do not wait 72. Go and report this. Eventually, if the breach is severe, you also have to communicate it to the data subject, but here you do not have any deadline here specifically. This means that if you have a high risk, you first go to the data protection authorities, and then, this is allowed, you can talk to your data protection authority and ask to the data protection authority whether you have to report to the data subject or not. So as you can see, this is a system that, although it might be very simple, required a lot of coordination and a smooth communication amongst entities, and especially that everyone knows what they have to do. If you automatize all of your process, this does not ensure you 100% that everything will be fine. Okay, so you need to have the people that they know what they have to do. This is very, very important. So awareness and training are crucial in this case. Now, I'm almost at the end, and I would like to mention two things. So one is the fact that with the GDPR, in terms of security and data breach notification, you have to consider another piece of legislation. It's called NIS directive, that it's related with cybersecurity. This is not the right moment to talk about this. But it says that if you face a data breach, if you face a personal data breach, you have to consider, you have to communicate the high-risk data breach, not simply to the data protection authorities, but to the CSI-RT. Now, if you have no idea, and it's perfectly understandable what is a CSI-RT, is this one. It's the Computer Security Incident Response Team. So you have to communicate it to them again, maximum 72 hours, also after you fix the problem, so you have a double notification system. Now, again, I'm not here to talk about the NIS directive, but it's crucial to strengthen the security, the cybersecurity's capability of the European Union, and it will affect specifically banking, financial market infrastructure, and so forth, amongst the other. Now, last thing, and I'm sure it's really the last one, is based on something, on a tool that it will be very important for you in the future to maintain your level, not simply of compliance, but also your strength in terms of security, with the processing of personal data, and it's called DPIA, Data Protection Impact Assessment. Now, very briefly, this is essentially a process that is not always mandatory, that essentially wants you to assess, to check, to monitor whether or not any new process, any new technology, any particular, I don't know, difficult or sensitive kind of data, sensitive personal data that you processed can have a discriminatory effect on people. Well, if you want to check, if you want to continue to be compliant and to protect people, to protect data subjects, you have to carry out a data protection impact assessment, and you can use different tools doing this, and the main approach is a risk-based approach. Now, the GDPR, let's say, provide an open list about this, and now data protection authorities are providing their own. But if you want to summarize, let's say, which kind of processing, very briefly, very generally required a mandatory data protection impact assessment, you can see evaluation and scoring. If you have a system, maybe an automatic system, not an automatic system, but a system for profiling your employees or your clients, for example, and evaluate them, for example, for a job application, for a mortgage or a loan application. If you use artificial intelligence, monitoring, you process sensitive data, genetic, biometric, fingerprints, facial recognition. This is something, for example, in the UK, it's extending more and more. For example, using for certain payment, certain payment purposes, the use of, for example, at school, of fingerprints, it's highly implemented. Matching data sets, this is one of your cases. So when you are merging different data sets, for example, for the creation of a common centralized register, would certainly require an evaluation and assessment based on a risk-based approach, a DPIA, and so forth. Now, this has to be done before you implement the process. So it doesn't work that, okay, I'm GDPR compliant, it's done, then I will do this DPIA in the future. No, when you implement, before you implement a process, a new technology, you have to assess if there is any risk. You have to remember that you have to be compliant, and that this is not a one-time exercise. This is not just a box that you have to check, like, I don't know, check, done, done. It doesn't work in this way. This is like an iterative process. You have to monitor, assess, review. This is extremely important throughout time. This is a living process. GDPR is not like a piece of paper that you have and you check whether you have ticked all the boxes. It's a living process, and it's just the first step of this development and digitalization of the European single market. This is another approach for what other countries are doing. This is why it's very important, again, when you're using personal data, and in this case specifically, that amongst the other things, you consider your obligation, your duties, because you're using something that it's not yours, and it's the oil of the 21st century. You're using data about people, that you remember how people can exercise those rights, and that you keep this asset, this resource protected, so you protect it properly. In this way, you can really ensure compliance, meet customer expectation, and improve your reputation, and ensuring trust. That is the real currency of the digital age. Thank you very much.